Thank you thank you very much, everybody, and great to get such an international group talking about a very important topic. Um, what I'd like to do is just outline some of my thoughts that sort of highlight a little bit about what's been talked about already. That the international human rights idea is not monolithic, but rather it's a subject to deep international divisions. It's subject to deep international divisions and controversy. A particularly long-standing controversy exists between countries, human rights advocates, and scholars who favor economic, social, and cultural human rights, mainly positive rights, such as the right to food, the right to work, and the right to adequate health care, and those in favor of political human rights, mainly negative rights, such as the right to liberty, freedom of thought, and freedom of expression, more US-centric style rights. The use of economic sanctions by the United States to achieve human rights goals abroad illustrates this divide. The United States has imposed economic sanctions to punish violations of civil and political human rights abroad with increasing frequency in recent years. This increased use has contributed to establishing international human rights norms, indicating that the behavior of the sanctioned country, usually violations of civil and political rights, is unacceptable under international law. But where economic sanctions cause human suffering, they jeopardize the economic, social, and cultural rights of civilians living inside the sanctioned country by, for example, destroying jobs, contributing to poor health conditions, and increasing hunger and poverty. Thus, the same sanctions that are imposed to end human rights violations of civil and political nature are causing human rights violations of economic, social, and cultural nature in the same country. Unfortunately, there remain a schizophrenic role of economic sanctions in international human rights law, with the United States' frequent use of economic sanctions. It reconciles the tension between scholars who argue sanctions violate international human rights law and those who argue that sanctions bolster international human rights by framing the tension as a conflict between economic, social, and cultural rights and civil and political rights. From this new perspective, sanctions do build up norms, but norms that favor civil and political human rights while undermining economic, social, and cultural rights. This effect is incongruous with international human rights law, which is predicated on the idea that human rights are universal. US unilateral sanctions deprive international human rights laws of this universality. They contribute to civil and political human rights norms favored by the United States at the expense of economic, social, and cultural rights favored by many of other nations and recognized on equal footing with civil and political rights in international human rights law. As a solution, the United States should only impose economic sanctions when it can be sure sanctions will not jeopardize economic, social, or cultural rights through the use of narrowly tailored smart sanctions. Sanctions legislation should be also drafted with a nod towards economic, social, and cultural rights by phrasing violations in rights-based language that clearly indicates and implicates economic, social, and cultural rights rather than merely citing civil and political violations as the impetus for sanctions. It can be argued that sanctions contribute to disrespect for economic, social, and cultural rights at home and abroad. Unlike the International Covenant on the Civil and Political Rights that requires state parties to ensure rights specifically within their own territories or subject to their sovereignty, the International Covenant on Economic, Social, and Cultural Rights requires state parties take steps individually through international assistance and cooperation to ensure fulfillment of the relevant rights. Unfortunately, the frequent imposition of economic sanctions that thwart economic, social, and cultural rights in other countries weakens this language by building customary law to the contrary. Therefore, rather than fostering the norm that countries should cooperate with other countries to aid fulfillment of the International Covenant on Economic, Social, and Cultural Rights obligations, the frequent imposition of economic sanctions reinforces the idea that the states not only do not have to take steps domestically to assist these rights, but also to jeopardize these rights in other countries with no repercussions. It's time for putting economic, social, and cultural rights in US sanctions policy. At this time in the United States, to send a message to the world that civilized nations should not contribute to the poverty, hunger, and poor health conditions through economic sanctions. So to do so, the United States might make the following course of action: is to, one, narrowly employ targeted smart sanctions, thus affirming the idea that economic, social, and cultural rights cannot be subjugated to civil and political goals. And two, that the United States should articulate these sanctions policies using economic, social, and cultural rights language in order to give credence to the economic, social, and cultural rights. Such measures will nurture the development of economic, social, and cultural rights into customary international law and help garner the respect and the notion that countries will be obligated to respect these rights both domestically and extraterritorially. The United States should only impose smart sanctions. Smart sanctions are narrowly tailored to minimize civilian suffering through measures which, as visa denials and freezing assets. This will prevent or at least minimize violations of economic, social, and cultural rights in target countries. The United States should formalize this foreign policy decision by articulating it clearly in the legislation authorizing sanctions. In this way, the United States will contribute to the state practice that pays homage to and consequently strengthens economic, social, and cultural rights. The United States should not be adverse to recognize economic, cultural, and social rights in this manner because it would be acknowledging a more US-centric negative elements of these rights. The United Nations would be condemning the imposition of sanctions, the state action that harms economic, social, and cultural rights. This allows the United States to skirt sticky issues surrounding positive aspects of these economic, social, and cultural rights. Secondly, the United States should include economic, social, and cultural rights as an official reason for implementing sanctions. This could simply entail adding language that acknowledges these rights violations are also occurring in the target state, and thus the United States is imposing sanctions to protect these rights in addition to the usual civil and political goals. If the US finds the entitlement aspects of economic, social, and cultural rights completely distasteful, it can simply choose to cite more negative aspects of the economic, social, and cultural rights in its sanctions policies. Obviously, it would be preferable to build fully fledged respect of comprehensive economic, social, and cultural rights, but nurturing the negative analogs of economic, social, and cultural rights would be a step in the right direction. The following old historic cases kind of clearly and hyperbolically illustrate the type of economic, social, and cultural rights that would have been included in US sanction regimes. This are a couple of times where the US might have provided sanctions where economic, social, and cultural rights might have been included in the sanctions legislation. So for example, back at the end of the Cold War, more than 40 years ago, Poland, though not mentioned as a official impetus for economic sanctions, economic, social, and cultural rights violations were also occurring in Poland that could have been listed in the United States in its sanctions policy. Poland had outlawed the Solidarity Labor Union in accordance with International Convention on Economic, Social, and Cultural Rights, Article 8(1)(a). Everyone has the right to form trade unions and to join trade unions of its choice. If the United States addressed such a violation in its sanctions legislation, it could be condemning a government action Poland outlawed a labor union rather than the entitlement, economic sanction, and cultural rights. Also, in Poland, it might have argued, in general, it was not able to meet the economic needs of its people. This would encompass numerous provisions of the ICESCR Article 6, for example, which requires state parties to ensure that the right to work, remuneration, fair wages, and workers, and ability at a decent living for themselves and for their families. Realistically, the United States would be less apt to address the pure entitlement right, where it was Poland's failure to act, than a specific incompatible commission issue. And then this was brought up before by the professor about the South African apartheid regime, which is another kind of hyperbolic example. So same as Poland at the end of the Cold War, the United States could have cited violations of the economic, social, and cultural rights as a reason for imposing sanctions under the former regime in South Africa, notably the discriminatory practices of apartheid and how it affected the work, culture, education, and health. All were within the scope of the ICESCR, which contains general provisions identical to the ICCPR, Article 2.1, that prohibits discrimination with regards to economic, social, and cultural rights is an incompatible state commission violation of negative rights rather than a step states that requires progressively to achieve in a violation of a positive rights. Therefore, this is another example of negative economic, social, and cultural rights that the United States would be more prone to accept in its sanctions policy. So to kind of wrap it up, the economic sanctions that historically caused suffering in Poland and South Africa in ways that disproportionately implicate economic, social, and cultural rights. There are many other examples that exist today that would be the same that could be implemented. Because these sanctions serve as a state practice which builds international human rights norms, imposing them in a fashion that undermines economic, social, and cultural rights and retards their growth into widely recognized and easy to enforce human rights. To rectify this, the United States must design sanctions and policies that acknowledge the importance of economic, social, and cultural rights and minimize human suffering. So it'd be ideal, obviously, if the United States would ratify the ICESCR, but that's unlikely. Therefore, I would argue that it would be less overt way for the United States to target the importance of economic, social, and cultural rights while continuing to utilize a favored tool of US foreign policy. Everybody wins, and the United States still can fight human rights abuses with economic sanctions. The population at large with the target country can receive relief from human rights abuses, and the economic, social, and cultural rights will no longer suffer in the shadow of the civil and political rights. So thank you very much for letting me address this group about this topic.